Imagine hiring the world's most qualified expert to save you in a murder trial. Now imagine that expert under oath, admitting the one thing that makes your entire defense fall apart. That is exactly what happened in the Lindsay Clancy trial on August 19th, and we need to talk about it. Let's be very honest with each other right from the start. August 19th was supposed to be a good day for Lindsay Clancy's defense team. They had their guy, they had their expert, they had their diagnosis, and for a few hours in that Plymouth County courtroom, it genuinely looked like they were pulling it off. Then, the prosecutor stood up, and everything changed. If you've been following this case, you already know the basic outline. Lindsay Clancy, a labor and delivery nurse from Duxbury, Massachusetts, is accused of strangling her 3 children, Cora, Dawson, and little Callan, on January 14th, 2023. She then jumped from a second-floor window, leaving herself with serious injuries. Her legal team is not arguing that she didn't do it. They are arguing that she was so severely mentally ill at the time that she cannot be held criminally responsible under Massachusetts law. That is the entire ballgame. So, on August 19th, the defense put forward their most powerful witness yet, Dr. Paul Zeizel, a forensic psychologist, a credentialed, experienced, serious professional who had spent considerable time evaluating Lindsay Clancy. And when he sat down in that witness chair and started talking, he made a genuinely compelling case. Here's what he said, and pay attention because this matters. Dr. Zeizel testified that Lindsay Clancy was not just struggling with postpartum depression. He went further. He said she was suffering from bipolar disorder with postpartum psychosis. And for anyone not familiar with that distinction, it is enormous. We are not talking about someone who is sad or anxious or overwhelmed, which, by the way, like plenty of people in this country are, and they don't strangle their children. We are talking about a clinical claim of complete disconnection from reality. Under Massachusetts law, and this is the legal standard that determines everything here, a person is not criminally responsible if, as a result of a mental disease or defect, they either did not understand that what they were doing was wrong, or they were incapable of conforming their behavior to the law. Dr. Zeizel looked that jury in the eye and said Lindsay Clancy met both of those standards. Both of them. He said she didn't understand that what she was doing was wrong, and she was incapable of stopping herself. Now, on paper, that sounds like a powerful foundation. And he kept going. He testified that in the weeks before January 14th, Lindsay was experiencing paranoid thoughts. She believed people could read her mind. She called suicide prevention hotlines in December. Yes, December, just weeks before the deaths, because she was in that level of distress. And then he said the thing the defense had clearly been building toward this whole time. She was hearing voices. Voices, Dr. Zeizel said, that were commanding her to kill herself. Now stop right there, because if you were a juror sitting in that box, you just heard something very specific and very significant. Voices commanding suicide. That is textbook command hallucination. That is one of the most extreme symptoms associated with acute psychosis. That is the kind of clinical detail that makes ordinary people, people who are not psychiatrists, people who are just trying to figure out what the truth is, sit back in their seats and think, okay, maybe this woman really was somewhere else entirely. The defense had done their job. The groundwork was laid. The diagnosis was on the record. The expert was credentialed. The symptoms were devastating. And then the prosecutor stood up. Plymouth County. Assistant District Attorney Nikki Thompson began her cross-examination of Dr. Zeizel with the calm, methodical energy of someone who has been waiting for exactly this moment. She wasn't theatrical about it. She didn't need to be, because what she was about to do required only one thing. A question, one very specific, very targeted question. She asked Dr. Zeizel this: before the killings, not after, not during the investigation, not during the months of legal proceedings, but before January 14th, 2023, did Lindsay Clancy ever tell any of her treating physicians that she was hearing voices commanding her to kill herself? And Dr. Zeizel said no. No. One syllable, one word. And if you understand why that matters, that single syllable just cracked the foundation of the entire defense narrative. Think about this for a second, and really think about it. Lindsay Clancy was not some isolated person with no access to health care. She was a labor and delivery nurse. She understood medicine. She understood mental health terminology. She was actively in psychiatric treatment in the weeks and months leading up to January 14th. She was seeing doctors. She was on medications, multiple medications, in fact, which has been a significant part of this trial. She was in communication with medical professionals. And if she was hearing voices telling her to kill herself, commanding her, as the defense put it, she never once mentioned that to any of those doctors, not once. Now you might say, well, people don't always disclose everything to their doctors. And that's true. Stigma is real, shame is real, fear is real. But here is the problem with that argument in this specific context. Lindsay Clancy was already disclosing. She was already calling suicide hotlines in December. She was already telling medical professionals she was struggling. She was already transparent enough that her treatment team was adjusting her medications. She was communicating. She just apparently never communicated the most extreme, most alarming symptom, the part where the voices were giving her specific orders. That is, at minimum, a very interesting gap. And the prosecutor made sure the jury understood exactly what that gap looks like, because here is where the testimony gets even more layered. Dr. Zeizel is not a neutral party who stumbled into this case. He was retained by the defense. He was selected by Kevin Reddington, Lindsay Clancy's attorney, specifically to evaluate her and testify on her behalf. That is completely standard in these kinds of trials. Both sides hire experts. That's how the adversarial system works. There's nothing inherently wrong with it. But then the prosecutor showed the courtroom a photograph of Dr. Zeizel standing next to attorney Kevin Reddington at a press conference. Not in a courtroom, not in a clinical setting, at a press conference, a public event where legal strategy gets performed for cameras and audiences and narratives get shaped before juries are even seated. The implication was not subtle. The prosecution was asking the jury to consider whether Dr. Zeizel was functioning as a truly independent clinical evaluator, or whether he had become, consciously or not, a part of the defense team's public relations operation. And this is where the phrase confirmation bias entered the room. Confirmation bias. It's a concept most people know intuitively, even if they don't use the technical term. It's what happens when you start with a conclusion you already believe is true, and then you interpret every piece of evidence through that lens. You find what you were looking for because you were looking for it. A forensic expert hired by a defense team to find evidence of insanity and who attends press conferences with the defense attorney is, the prosecution suggested, someone who may have been looking for psychosis rather than evaluating for it. And if the voices commanding suicide only emerged as a documented clinical narrative after the killings, after the defense strategy was in place, after the expert evaluations began, then the prosecution's version of events becomes genuinely difficult to dismiss. Let's be clear about what the defense is not saying. They are not denying that Lindsay Clancy suffered from serious postpartum mental illness. There is substantial evidence that she did. There is evidence of medication changes, of distress, of psychiatric treatment, of genuine suffering. Nobody in that courtroom on either side is arguing that January 14th happened because Lindsay Clancy was a happy, stable, functioning person. That is not the debate. The debate is whether her suffering reached the specific legal threshold of psychosis severe enough to eliminate criminal responsibility. And the prosecution's argument is becoming increasingly clear. They are not saying she was fine. They are saying the narrative of the voices, that specific legally critical detail, was constructed after the fact. That the story of command hallucinations ordering her toward violence was built layer by layer in the months following the killings, shaped by interviews with defense-hired experts and legal strategy sessions and press conferences. That is a very different thing from a woman who, in real time, in December and early January, was being driven by psychotic voices she couldn't escape. One version is a tragedy with no criminal culpability. The other is a tragedy with a defendant who understood on some level what she was doing. And the jury is going to have to decide which version they believe. Here's where things stand as of August 19th. The defense was signaling that they may be close to resting their case, which means we could be moving very soon into the prosecution's rebuttal witnesses, experts and evidence the state brings specifically to counter what the defense has presented. And after that come the closing arguments. The closing arguments are where this case, already one of the most emotionally exhausting trials in recent Massachusetts history, is going to reach its final form. The defense will stand up and say, This woman was shattered by postpartum psychosis. She was let down by a medical system that failed to catch how sick she truly was, and punishing her for what she did in a psychotic break is not justice. And the prosecution will stand up and say, the evidence of psychosis that meets the legal standard was never documented in real time, and the version of events we've been given was assembled after the fact to serve a legal defense. Both of those arguments have weight. That's what makes this case so genuinely difficult to watch. Because somewhere in the middle of all of this, on like the legal strategies, the expert witnesses, the press conferences, the confirmation bias arguments, the photographs, there are 3 children, Cora, Dawson, Callan. The youngest was less than a year old, and whatever you believe about Lindsay Clancy's mental state, whatever verdict this jury ultimately returns, those 3 children are the reason any of us are paying attention. This is not entertainment. This is a family that was destroyed in a single night, and a system now trying to figure out what to do with the wreckage. The question of whether Lindsay Clancy heard voices that commanded her actions before January 14th, or whether that story emerged only after, is not just a legal technicality. It is the entire moral and factual center of this trial, and Dr. Zeizel, in that one moment when he answered no to the prosecutor's question, handed the jury a reason to doubt. Whether that doubt is reasonable, whether it's enough, we're going to find out. I want to hear from you. After everything you've just heard about August 19th, about the voices that were never reported to treating physicians, about the photograph at the press conference, about the confirmation bias argument, where do you land? Do you think the defense's psychosis narrative is clinically real? Or does the prosecution's timeline make more sense to you? Tell me in the comments. I read every single one, and this conversation is worth having thoughtfully. If you are not subscribed yet, now is genuinely the time. The closing arguments in this case are coming, and the verdict is going to be one of those moments where you want to have the full context going into it. Hit subscribe, turn on notifications, and I will have you covered every step of the way. This case is not over, not even close.